Hello viewers, I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In today's lecture, we will learn about the Privy Council as a court of appeal. My dear learners, the objectives of the present module are, firstly, to understand the meaning and significance of the Privy Council. Then, to trace out the historical perspective of the Privy Council. Also, to examine the nature and extent of the Privy Council's jurisdiction. Then, to highlight the composition of the Privy Council and to review the significance as well as the drawbacks of the Council. Let's begin with the prologue. A Privy Council is a body that advises the head of a state or a nation, typically but not always, in the context of a monarchic government. The word privy means private or secret. Thus, a Privy Council was originally a committee of the monarch's closest advisors to give confidential advice on state affairs. The Privy Council played a significant role in shaping the administration of justice in India prior to independence. As far as the historical perspective is concerned, the origin of the Privy Council dates back to the Normans who conquered England in 1066 AD. At the beginning of the 11th century, the Normans introduced a strong central government in England for controlling their executive, legislative as well as judicial departments. There was a supreme federal council of Normans. It was known as Curia and it acted as the agency of Normans to rule England. Through it, the whole administration in England was controlled. However, gradually with the passage of time, Curia gets divided into Curia Regis and Magnum Concilium. Out of them, Magnum Concilium was to deal with executive matters, whereas Curia Regis performed judicial functions. The Curia Regis was a small body consisting of high officials of the state, members of the royal household and certain clerks chosen by the crown itself. Their duty was to advise the king in matters of legislation and administration and to deliver justice. In fact, the Curia Regis acted as a final appellate court for England and the English Empire. The Curia Regis conducted its business through two kinds of meetings. Firstly, meetings of the entire Curia and secondly, meeting of the smaller Curia. Gradually, the Curia Regis came to be considered as the advisory body of the king, performing most of the vital functions in the field of judicial administration. Finally, during the regime of Henry II, there was a tremendous increase in the judicial functions of Curia Regis, and it led to the formation of two different common law courts in England. They are number 1, King in Parliament, that is Court of House of Lords. Second, King in Council, that is Court of Privy Council. The former became the highest court of appeal for courts in England, while the latter acted as the highest court of appeal for all British possessions and settlements beyond the seas. In this way, the Privy Council was established during the middle of the 16th century. It thus acted as the advisory body of the king with regard to the affairs of the state. headquarters of the Privy Council was at London, and its powers were implemented through the means of royal proclamations, orders, instructions, etc. Dear learners, let's discuss about the nature and extent of the Privy Council's jurisdiction, which was explained in a leading case, Alexander E. Hull and Company versus A. E. McKenna of 1926. Lord Haldane stated the nature of the jurisdiction as follows: we are not ministers in any real sense. We are a committee of privy councillors who are acting in the capacity of judges, giving advice to His Majesty, but in a judicial spirit. The sovereign gives the judgment himself and always acts upon the report which we make. Our report is made public before it is sent up to the sovereign in council. It is delivered in a print form. Thus, in practice, the Privy Council was the last court or apex court of appeal for colonies and dominions, but the decision of the council was always in the form of advice and not as a final order. Let's discuss the composition of Privy Council. As far as India is considered, the Privy Council acted as an appellate body since 1726 with the establishment of Mayor's Court in India. Earlier, the Privy Council used to do its work by means of a system of committees and subcommittees. However, the committees did not have permanent existence, and membership and mostly members were the persons with little judicial experience. Naturally, it affected the administration of justice. In 1828, Lord Borgham criticized such a constitution of Privy Council, keeping in view the extent and importance of the appellate jurisdiction of Privy Council. Subsequently, in 1830, he became the Lord Chancellor, and during his regime, the British Parliament enacted the Judicial Committee Act 1833 in order to reform the constitution of the Privy Council. In this way, officially, the Privy Council was created on 14th August 1833 by the Act of Parliament. The Act empowered the Privy Council to hear appeals from the court in British colonies as per the provisions of the Act. Accordingly, under this Act, the quorum of the Judicial Committee of Privy Council was fixed to be 4. It was composed of Lord President, Lord Chancellor and other Chancellors holding judicial offices. This quorum was reduced to 3 in 1843. The recommendations to the Crown were given by the majority of the quorum. Thereafter, by means of Appellate Jurisdiction Act 1908, this membership of the Judicial Committee was extended. It also empowered His Majesty to appoint certain members not exceeding 2. These were nothing but the judges of the High Court in British India. Thus, some of the members of the Privy Council were the persons versed in Indian laws. As Privy Council was the highest court of appeal, therefore, appeals from various courts lied to it. Appeals from courts in India to the Privy Council, that is, the Crown's courts and the Company's courts, lay to the Privy Council as of right. These appeals can be discussed as follows. Firstly, appeals from Mayor's Courts of 1726. In 1726, in the charters of the Mayor's Courts, established in the port cities of Bombay, Madras and Calcutta, earliest formal provisions for appeals to the Privy Council from the courts located in India were provided. In fact, Bombay was the Crown territory acquired from the Portuguese as royal dowry, transferred to the company, while the settlements in Madras and Calcutta grew around the company's trading stations and on lands leased from Indian rulers. The first appeal from the Mayor's Court lay to the Governor and Council of the settlement. The decisions of the Governor and Council were to be final in all cases involving a subject matter up to 1000 pagodas in value. In cases involving a subject matter more than 1000 pagodas, a further appeal from the Governor and Council lay to the King in Council within a period of 14 days from the date on which the judgment appealed against was recorded. Then, appeals from the Supreme Court of Calcutta, Fort Williams under Regulating Act 1773 lied to Privy Council. This act empowered the Crown to issue a Supreme Court charter at Calcutta for establishment. Thus, the Crown issued the Charter of 1774 to create a Supreme Court in Calcutta, and it abolished the respective Court of Mayor. Section 30 of this charter provided the right to appeal to the Privy Council in civil matters from the judgments of the Supreme Court if two requirements were met. Firstly, the amount involved exceeds 1000 pagodas. Secondly, where the appeal is filed within 6 months from the date of decision. Appeals from the Recorder's Court under the Act of 1797. In the same way, the Act of 1797 replaced the Mayor's Court at Madras and Bombay with the Recorder's Court and provided for direct appeals from these courts to the Privy Council. Thus, the right to appeal from the King's Court to the Privy Council was well recognized. Besides this, there were Companies Court, that is Sadar Diwani Adalat and Sadar Nizamat Adalat. They also recognized the right to appeal to the Privy Council from their decisions. Accordingly, the Act of Settlements 1781 provided for the right to appeal from Sadar Diwani Adalat at Calcutta in civil matters also. Appeals from Sadar Adalats. Before 1781, that is the Act of Settlement, there was no provision for appeals to the King in Council from Sadar Adalats in Bengal, which were established to hear appeals from the Mofusils. The Act of the Settlement 1781 made Sadar Diwani Adalat a court of record. Therefore, appeal from its decisions could lie to King in Council in civil matters involving subject matter worth £5,000 or more. Later, a Sadar Diwani Adalat was established at Madras in 1802. Appeal against its decision in civil matters involving rupees 45,000 and upwards lay to the Sadar Diwani Adalat at Calcutta. However, later by the Act of 1818, the Sadar Diwani Adalat at Calcutta relinquished the authority to hear appeals from the Sadar Diwani Adalat of Madras. Such appeals lay directly to the King in Council. It is to be noted that there was no restriction as to the appealable amounts in such appeals. In Bombay, the right to appeal to the Privy Council was allowed as early as 1812 under the Regulation Act of 1812. The appealable amount was £5,000 in such cases. appeals to Privy Council from High Courts. The High Courts were established in 3 provinces in 1861 under the Indian High Courts Act 1861. It was the amalgamation of the courts of king and the courts of business. This act provided for the right to appeal from any of its decision to the Privy Council from High Courts, except in criminal matters. In addition to this, there was a provision of special leave to appeal in certain cases to be certified by the High Courts. The Charter of the High Court also made it the supreme and final court of appeal in all cases, civil and criminal, decided by inferior courts except such as possessing the requisite importance, pecuniary or legal, demanding a further appeal to the Judicial Committee of the Privy Council. Appeals from Federal Court in India to Privy Council. The 1935 Government of India Act provided for the creation of a Federal Court in India. The Federal Court was granted original exclusive jurisdiction to decide disputes between the centre and the constituent units. The provision was made for the filing of appeals from the High Courts to the Federal Court and the Privy Council from the Federal Court. The Federal Court also had jurisdiction to grant special leave to appeal, and a High Court certificate was essential for such appeals. Another important point is regarding abolition of jurisdiction of Privy Council. In 1933, a white paper was issued by the British government for establishment of the Supreme Court in India so as to hear appeals from Indian High Courts. It was the first step in avoiding the jurisdiction of the Privy Council. After Indian independence, the Federal Court Enlargement of Jurisdiction Act 1948 was passed. This act enlarged the appellate jurisdiction of the Federal Court and also abolished the old system of filing direct appeals from the High Court to the Privy Council with or without special leave. Finally, in 1949, the Abolition of Privy Council Jurisdiction Act was passed by the Indian government. This act accordingly abolished the jurisdiction of Privy Council to entertain new appeals and petitions, as well as to dispose of any pending appeals and petitions. It also provided for transfer of all cases filed before Privy Council to the Federal Court in India. All powers of the Privy Council regarding appeals from the High Court were conferred to the Federal Court. Thereafter, with the commencement of the Constitution of India in 1950, the Supreme Court has been established and is serving as the apex court for all purposes in India. It hears appeals from all the high courts and subordinate courts. With this, the appellate jurisdiction of the Privy Council finally came to an end. Let's understand the role of Privy Council in the development of laws in India. The Privy Council played a significant role in the development of the Indian legal system. MP Jain observes that it served as a bridge between the Indian and the English legal systems, over which legal ideas travelled from England to India. It aided the cause of justice for more than 200 years for Indian courts prior to independence. As far as the judicial institution is concerned, the Privy Council was unique and unparalleled among all the courts around the world. It set the task of ascertaining the law, formulating legal principles, molding and shaping the substantive laws in India. It also helped in the introduction of the concept of rule of law, on which we have set up the whole philosophy of our democratic constitution. Besides, the Privy Council also led to the introduction of common law in India. This formed the basis of almost all the present Indian laws. The contribution of the Privy Council in personal laws like Hindu law and Muslim law is also noteworthy. It acted as a channel through which English legal concepts came to be assimilated with the body and fabric of Indian law. It always insisted on the maintenance of highest standards of justice and judicial procedure, especially in the field of criminal justice. In this way, the decisions of the Privy Council have enriched Indian jurisprudence in many respects. Its contribution to the statute law, personal laws and commercial laws is of great importance. Thus, during the period of 1726 to 1949 and specifically after 1833 and onwards, the Privy Council has played a magnificent role in making a unique contribution to Indian laws and the Indian legal system. The fundamental principles of laws as laid down by the Privy Council are considered as pathfinders for the Indian courts still today. The Privy Council assumed the role of the sole interpreter of the Federal Constitution under the Government of India Act 1935, and in this capacity it has played a commendable role in moulding the Constitution. At present also, the Privy Council commands a great respect among Indian lawyers, judges as well as the Indian public as the highest judicial institution. Some of the principles laid down by the Privy Council are still followed by the Supreme Court of India. The view taken by the Privy Council is binding on the High Courts in India till the Supreme Court has decided otherwise. One of such instances can be given in the form of principle of absolute liability as propounded by the Supreme Court in the historic oleum gas leak case. Thus, as a whole, the contribution of the Privy Council is considered as remarkable for the development of the Indian legal system and Indian judicial administration. It has played a great unifying role in shaping divergent laws in India. Here, it is important to underline the drawbacks of Privy Council. Now, despite the contribution of the Privy Council to the development of Indian legal system, its judgments have been criticized for not being in consonance with the accepted Indian norms. This was particularly true with its decisions relating to personal laws of Hindus and Muslims. Since the members of Privy Council were all English judges, they had little knowledge about the Indian customs and traditions. Moreover, the solicitors in England were engaged by the attorneys of the Indian Supreme Courts. These solicitors, being ignorant about the Indian ways of life, lacked adequate knowledge about the practices of Indians. Therefore, they were not in a position to plead the cause of their clients successfully. Another shortcoming in the functioning of the Privy Council was the enormous expenditure which the parties had to incur in order to move an appeal to the Privy Council. As a result of this, only rich and influential parties could resort to this course of justice, and the poor were deprived of this remedy due to their economic constraints. Furthermore, the Privy Council was the highest court in the Indian judicial system. However, being located in England, it gave an impression that our sole dependence was on Britishers in matters of law and justice. But there seemed to be little force in this argument. The Privy Council is recognized for setting high traditions through its judicial detachment and integrity that subordinated everything to the rule of law. It is also acknowledged for its conscientious regard for the rights and justice, not only between subject and subject, but also between state and subjects. We shall also see what is the precedential value of Privy Council's decisions in India. After the establishment of Supreme Court on 26 January 1950, the decisions of Privy Council have no compelling force on Supreme Court, but are entitled to great respect. Hence, the Supreme Court can decide independently. The High Courts are, however, bound unless they can point out a decision of the Supreme Court to the contrary. Dear learners, from the above discussion, it is evident that the Privy Council has rendered a meritorious contribution in the development of the Indian legal system and judicial institutions. It introduced many fundamental legal principles in the Indian legal system. It shaped the judicial institutions in India. As a whole, its role is very significant in developing the legal system in India as it exists presently. The procedure of lodging appeals with the Privy Council and of their being decided was modified several times, most importantly in 1833. In general, its role in improving the legal system in India as it currently exists is very critical. I hope you find this lecture insightful. Thank you very much.